question.
Because Justice Gorsuch has stated one view. I think Justice Sotomayor and Justice Barrett have said this question has not been ruled on yet. So it's...
Yes, Your Honor.
And the Ninth Circuit, Fifth Circuit's looked at, but the Ninth Circuit has not adjudicated this precise question.
Not that I'm aware of. So it's for that reason that we argue that this court doesn't have the authority to issue the remedy that plaintiffs seek here.
What's your reaction to your opponent's point about there's a difference between vacator under 706 or postponement and injunction, in part because an injunction runs against individuals who are subject to immediate contempt proceedings, whereas a vacator only operates on the agency action, and any contempt is another step removed, and therefore is a less, quote, drastic remedy?
I think that falls into this clever workaround language. Functionally, they're operating the same. So just because you have to take one more step to enforce the postponement, it's still restraining the operation of the statute.
And what about the general presumption of reviewability, given the basic value of separation of powers in our government, that when you remove effective reviewability, that perhaps by way of relief, because you can't get damages, obviously, it essentially nullifies any kind of meaningful judicial review, that the presumption generally obtains against that, and statutes should be construed narrowly to the extent they purport to remove judicial review. How does that operate here?
I think here, right, there is that presumption unless Congress is clear, and I think that Congress has been clear in the language of both 1252 F1 and, as we'll discuss later, 1254A.
Is there anything in the congressional record on this particular section that sheds light on its application to APA actions?
Not that I'm aware of, Your Honor. I have not had time to go back and look at the congressional record of 1252 F1, of 242 F1.
All right. Well, let me give Mr. Arlington the chance to, if you have one more comment, then I'd like to move on to the 1254B5A question.
Just very quickly, a few things about what Ms. Wong just said. The point about in Ken, Your Honor, is not about 1252 F1. In Ken is not construing 1252 F1. It's construing the next neighboring provision, 1252 F2. But the reason why I mention it is because it explains why is not an injunction. And 1252 F2 contains a different kind of bar, or just sets a very high standard for certain kinds of injunctions. And its explanation for why a stay of removal is not an injunction or an immigration judge saying this person can be deported, and the court is saying that staying that, which is what happens when you have a deportation order that's being reviewed on a petition for review, or a removal order is being removed on a reviewed on a petition for review. I think staying that is not an injunction. That's the holding of the Supreme Court in Ken. And they say it's a stay, it's not an injunction. You know, what's the difference? And they say almost exactly the same argument that that I'm making here today. And it's also, as I said, the reasoning of the Fifth Circuit. The second thing, I just want to be very clear about this. The Fifth Circuit ruled on our side of this question, and I think 5 district courts have ruled on our side of this question. No court in this country has ruled on their side of this question. Then the last thing I'll say is, if Your Honor, we're actually going to kind of try to go down the road of applying the savings clause at the end of 1252 F1, which Ms. Wong referred to, the other than with respect to individuals in proceedings, there are lots of Venezuelan TPS holders who are in proceedings, or who it's actually. Let me modify that. It's the phrase is against whom proceedings have been initiated. other than an individual alien against whom proceedings have been initiated. Our plaintiff, MH, I think you were referring to them earlier, if I remember, the 3-year-old son and the 7-year-old, they have a check-in with ICE in May. There's another plaintiff, ER, so she's a 7th grade daughter, has a check-in with ICE in June. So those are people who definitely fit within the exception. There are, there's more than 84,000 NTPS, the TPS Alliance Venezuelan members. There's obviously lots and lots of others. So it would be a mess to try to limit this court's ruling in some way via that exception. And I think much more straightforward from an administrative standpoint to postpone the effective date of the rule and preserve the rights, just like every other normal APA case, Your Honor.
Well, that's sort of, I'm not sure which way that cuts, because if there are folks who are could get relief under the savings clause, I guess the comeback to that is that, well, then they should seek individualized release and not a wholesale invalidation of the Secretary Noem's vacator.
Well, so to be clear, everybody loses their employment authorization. And there's many reasons why I think this provision doesn't apply that we didn't get into. One of the many is that once TPS expires, you lose your employment authorization. That applies to everyone.
That wouldn't be a proceeding brought under this part, such part.
I think, other than with respect to an individual against whom proceedings have been initiated, refers to removal proceedings. That's my understanding of what that term means. And then, there's obviously a number of massive. So I would argue the harm that we're talking about, and the $3.5 billion for the April crowd and about $8 billion for everyone, that's triggered totally aside from whether or not people are put into removal proceedings. But the reason I raise this is to say that it doesn't make any sense that a provision like this, with an exception clause like that, would apply to this sort of programmatic policy where you're going to strip all these people of their employment authorization well in advance. But even if you reject our view, you'd have to split with the Fifth Circuit and all these district courts, and you'd have to explain why this is consistent with APA doctrine, which they still haven't done. All they've said is they think all the APA doctrine is wrong. But even if you went that road, we wouldn't be done. We would then, we'd come back here and say, there's thousands of people who, even under their interpretation, are entitled to relief and could be getting relief in this action. In this case, it doesn't say that you have to bring it in removal proceedings. It just says that you can't grant an injunction other than with respect to an individual against whom proceedings have been initiated. So, it's just all to say, like, they point to this as though it's a solution to the problem, but it just opens its own massive can of worms.
Well, I'm not sure they're saying a solution. They're saying it informs the interpretation of the rest of the statute.
Well,
you've got a
then,
savings clause that's been delimited, and therefore that would, I guess, argue for a broader interpretation of the front end of the statute.
I see. So then my answer to that would be the point I just made a minute ago, which is that there's a huge amount of harm caused by the termination, which cannot be addressed by waiting to raise challenges in removal proceedings. So it doesn't argue for a narrow interpretation on that basis. And the other thing I would say, Your Honor, is, as I understand it, their position is that the illegality of TPS, of the TPS termination and vacatur, cannot be raised in removal proceedings. That was their position last time, anyway, in Ramos, that we couldn't litigate these questions we're litigating now. Of course, the individual in removal proceedings couldn't compel the production of the administrative record, what we started the hearing with. So for both of those reasons, I would argue that the existence of the savings clause cannot be sufficient to resolve the problems that would be created by stripping.
In other words, there's no other forum to litigate this. It would preclude entirely judicial review, hence the rule of construction about narrow construction of such.
Yes, Your Honor.
Prohibitions.
Yes.
All right, we got to move on. Thank you to the other jurisdictional question, and whether that means judicial review, which is barred with respect to, quote, any determination with respect to the designation or termination or existence or extension of a designation
of a foreign state. We did look at this question, and so did the Ninth Circuit panel in the now vacated Ramos decision in the Ninth Circuit. But the vacated decision, even the majority there, reached conclusion that the sweep of 1254B5 is limited, that determination, which is a key term here, pertains to review of the underlying considerations and reasoning employed by the Secretary in reaching her country-specific TPS determinations, determining whether or not conditions are so adverse that it's dangerous to send people back. Those are the kinds of things that are generally not reviewable, but that sort of procedural or collateral matters can be, and even under that framework, which is not binding here because that decision was vacated, but it's an indication of at least how 3 judges look at it. You look at such factors under McNeary, as I understand it, as cited by the vacated Ramos decision. Is the review based on the merits of the individual situation, or is it a broad challenge? Is the administrative record for a single decision, does that have any relevance? Is that needed in the determination? And is the examination peculiarly within the agency's special expertise or integral part of its institutional competence? I mean, those are some factors that you looked at to determine whether it's that a determination or whether it's really collateral to that. And so here, if we look at the whole question of the vacator, not necessarily the termination, but just the vacator of the 2023 statutory framework of the TPS statute allows and has implicit authority or not. That doesn't sound like the kind of determination of country conditions that the Ramos case was referring to. And if you look to the reasons justifying the vacator, again, they were not so much based on analysis of country conditions, but really sort of whether what was done by Secretary Mayorkas before was so novel and perhaps inconsistent with the TPS statute, as was mentioned, and maybe, ultra virus or whatever, but again, didn't seem to be based on country conditions or anything akin to that. And so the record that you would look to, the agency expertise about evaluating country conditions and the safety of the return of folks doesn't seem to be at play here. So it seems to me, although this case is a slightly different question that's being raised than in Ramos, the framework, if we were to accept Ramos, at least the majority opinion, would suggest that 1254B5A would not bar, because this is not a, quote, determination within the meaning of that statute. So I'm going to let the government respond first, and then I'll give you a chance to respond, Mr. Arlell.
Your Honor, I think we need to go back to the text of the jurisdictional bar at 1254A-B5A. And the language is any determination of the Attorney General with respect to a designation or termination or extension. And that any has a broadening effect of the word determination. Since the last time we were here arguing this statute, the Supreme Court has weighed in again in the Patel case, Patel v. Garland, and has stated that any does have a broadening effect to the next word, to that determination. And so here, where the statute provides inherent authority to revisit decisions, the decision by Secretary Mayorkas had not even gone into effect. The Secretary Noem came and was able to relook at that decision and determine that it didn't meet the statutory needs. She noted, if I find my language, she did note that she was relooking at it not only to untangle confusion and provide an opportunity for informed determinations, not only to untangle confusion, but to provide herself, she gave herself the space to make an informed determination regarding the TPS designation, and then clear guidance from the president that she was to look, the guidance being that she was to look at these designations and determine if they met the statutory requirements of the TPS statute. So I'm mixing arguments here, but the inherent authority to issue the vacatur is then swept up once she makes that decision to vacate the extension. That decision is then swept up under 1254A B5A as any determination, as one of the
Well,
determinations.
but in your reading,
underpinning.
if the bar of 1254 is so broad, we wouldn't even reach the question whether she had authority or not. We wouldn't even reach the question whether what she did was reasonable. There would just be no review. That whatever she did, no review, period.
I think that the Ninth Circuit and Ramos and yourself indicated that you could look at legal questions surrounding the interpretation of the statute. So,
Okay, so you could have judicial reviews to in construing the statute, for instance, and determining whether or not there was implicit authority or not?
yes, Your Honor.
Okay.
But then once you look to determine that that the statute does provide that inherent authority, implicit authority, from there, the decision itself and the evidence and decision making by the secretary, then you look at the language of the statute and note that, and it is a determination relating to, in this case, an extension.
Okay, so as I understand it, you would concede that looking at the statutory question, the first question of whether there was implicit authority under the statute, which is a matter of statutory interpretation, is within the realm of what this court can do. But if then I were to find that there was authority to do so, the way she exercised it, the reasons why she exercised it, that's where the bar on judicial review would apply. It's like a determination of a country condition. It's
Correct. It
determining-
falls within the same sort of analysis and what the secretary can look at, and that is open for the secretary.
Okay.
And it's not, it's not the first time that a vacatur has occurred. As we point out, Secretary Mayorkas did the same thing when he reconsidered and vacated the 4 terminations that were at issue.
But it's the first time in 35 years that a vacator has been used to terminate an extension or a designation.
It's the first time that a vacator has been used to vacate an extension, correct? But that's a results-oriented analysis. If the statute provides authority, the statute provides authority for a secretary.
Well, it
to do
might,
that.
and I don't know how relevant it is that it's never been exercised until Secretary Mayorkas did it in the other direction, that is to vacate the termination, which effectively extended it, and now this time to vacate an extension, which effectively terminates it.
Correct.
Whether that agency practice for up until that point for 30-something years is informative of an interpretation, perhaps. But clearly until the last couple of years, no secretary has ever done that, right?
Correct, not until.
In either direction.
In either direction, Your Honor.
Well, let's talk about since everybody agrees that we should first determine, and it is appropriate for this court to determine whether or not there is this inherent authority to revisit. Again, I take it there's no direct cases on point. We're trying to discern from this statute.
No, Your
The
Honor,
rule.
not on the statute.
Yeah.
We do point to other cases that note if there's no rubric explaining how a decision can be reconsidered, then that authority is implicit in the statute. And I know that plaintiffs say, look, the statute lays this out at 60 days, and you have to look you can't revisit a decision if you're not within those 60 days, and this extension has already taken place. The 60-day language from the statute refers to the termination. It doesn't refer to anything else. So this was not a termination. This was a vacatur that allowed her to then follow the statute for the termination.
Well, let's look at that. So the statute does specify that once there's been a designation, It's supposed to be reviewed periodically, no later than 60 days before the end of that designated period. And if the Attorney General determines that the foreign state no longer meets the conditions for designation, then the Attorney General shall terminate the designation by publishing a notice, and the effective date of the termination is either 60 days after the date that notice is published, or if later, the expiration of the most recent previous extension under the subparagraph. So in other words, you can't terminate, now I'm not talking about vacate, but you can't terminate midstream. You have to at least take it to the end of the period. And the periods are either 6 months, 12 months, or up to 18 months. That's within the discretion of the secretary in the first place for designating. But there is no ability to terminate prior to that. You can do the notice, give notice termination, even months, several months in advance, but the effective date can't be until at the earliest would be the expiration of that period, the original period.
That's correct, Your Honor.
So why isn't the Secretary Nome's vacator of the extension effectively, how's it any different from a termination? I mean, what's the difference?
What's the difference is that the vacator allowed her to then look at the country conditions in Venezuela and determine whether that second piece of the statute comes into play. Because you do have to look at the language of what Venezuela was designated under. And it was designated under the extraordinary and temporary conditions subsection. That subsection continues to say, if I can find it, if it's not contrary to the national interest. And so that's what Secretary Nome was doing. So the vacator allowed her, the vacator gave her the space, I keep saying that, but it gave her the time to fit within the time frame that the statute permits.
But if you step back, the effect of the extension in 2023 was to give folks both under the 2021 and the 2023 designations until, what is it, October or September, October of 26,
Yes.
correct?
Mhm.
And so by vacating and then deciding she could terminate, some folks would not have the benefit. So it does shorten, it could shorten the period. So it is in effect an early termination. At the end of the day, that's what's happening.
Secretary Mayorkas made that determination in January, and Secretary Nome came in, and I think maybe 10 days later. So I think most individuals understood that TPS had an end date of April 7th if they were under, sorry, of April 2nd if they were under the 2023 redesignation. So the reliance interest there was the 10 days between, the 10 days to 2 weeks between Secretary Mayorkas's extension and Secretary Nome coming in and vacating that decision.
Well, we'll talk about the reliance interests in a moment, but I'm just talking about as a matter of sort of statutory construction. If Secretary Nome could not have terminated earlier than the date of the extension date, how could she use the tool of vacator and then termination to essentially effectuate an earlier termination date? I mean, that's the upshot of all this.
Yes, Your Honor, because she used that periodic review language, and it says that the secretary may periodically look at the conditions, look and determine whether or not that extension or that designation, those conditions still exist. And so in that periodic review, she determined that because the registration, the re-registration periods were overlapping, because she wanted to look at the conditions in Venezuela and determine whether or not the Venezuelan TPS designation, the redesignation met the standards of whether or not the extraordinary and temporary conditions still existed and if it was contrary to the national interest. That periodic review allowed her to go back and look at that extension. And then she was within the time frame to terminate.
It just seems to me it's still the same thing in substance. At the end of the day, it's an earlier termination that had otherwise been granted prior, and whether you call it a straight termination or a vacator followed by a relook and then a termination, the net effect is the same. And to use Justice Gorsuch's word, this looks like a clever workaround.
Well, and I go back to Mayorkas's own language that notes that the TPS statute does not limit the secretary's inherent authority to reconsider any TPS related determination and upon reconsideration to change the determination.
Right. Well, that's one secretary's interpretation of the statute. Maybe right, maybe wrong.
Well,
Let me ask,
it's both secretary's interpretation of the statute.
Well, there's two of them. On the other hand, we've got the statute, and doesn't, even as a matter of statutory interpretation, putting aside whether this is a workaround or not, where a statute sets forth temporal expectations and time blocks and has specific markers, doesn't that suggest that an agency can't use whatever implicit authority to contravene that? That is, to do something. It is contemplated that there are clear time markers set forth in the TPS statute, and to take actions that effectively shorten the time seems like that's something that's not within the power of the agency to do once Congress had set forth temporal expectations and markers.
Well, I will note that the extension hadn't gone into effect. If you look at the language of the extension itself, it says this goes into effect on April 3rd. And so that is the decision that the secretary is reviewing and reconsidering. The vacatur had already gone into effect, but the extension had not. And so I go back to the statement that individuals were under the 2023 redesignation and extension. These individuals before, I'm getting all confused. The April 2nd deadline was one that individuals who had registered for TPS under 2023, under the 23 designation, they understood that to be the end of TPS. So then we have the 10-day period where Mayorkas extends, but we can't ignore the fact that a new administration is coming shortly thereafter. And so I think those 10 days to 2 weeks and the reliance interest there, and Secretary Noem recognizes that. That's overcome by what she finds to be the national interest concerns that she points out in her termination.
All right, let me hear the response to the argument that there was no violation of the statute, the time frame of the statute, since this was a vacator and the secretary gave herself time before making a termination decision. So it's not synonymous, and also the argument that there was the extension by Secretary Mayorkas was not effective, and therefore, I guess the argument is there was no real termination.
Thank you. Good morning, Your Honor. Jessica Bunsell.
Yes.
To begin with the argument that because the vacatur was made within the 60-day period, it somehow didn't violate the fixed time terms of the TPS statute, Your Honor, that's incorrect. Under the statute, subsection B3B, that says that a termination cannot take effect earlier than 60 days after publication of the termination notice, or if later, the expiration of the most recent previous extension. And so when Secretary Mayorkas determined on January 17th that the conditions for Venezuela's TPS designation continued to be met, that determination under the statute triggered an extension. The extension flowed from that determination. And once that extension was on the books, this fixed time period set forth in the statute controls when a termination can take effect.
So which section do you cite for the proposition that once the determination by Secretary Mayorkas was made, that triggered the extension at that point?
Your Honor, in subsection B3C of the statute provides that if the Attorney General does not determine that the foreign state no longer meets the conditions. And so on January 17th, Secretary Mayorkas determined that not only did it not no longer meet the conditions, he made an affirmative determination that conditions continued to be met. Under the statute, the period of designation of the foreign state is extended. If you look in the January 17th notice also, Your Honor, we disagree that that notice was not effective until April 3rd. The extension of work permits and lawful status began on April 3rd, but that January 17th notice says that TPS holders, for example, can show that notice to their employers with their EAD with that April 2nd expiration date as of January 17th. And the employer can take that to mean that their employment authorization is extended. It also opened registration to apply to extend your TPS through October 2nd, 2026 on January 17th. So that notice did take effect immediately, both under the statute and by its own terms, Your Honor.
And then I guess that stands in contrast to Part B, which is termination that has time deadlines. There's a sort of breathing period. That is, you have to give at least 60 days notice before it's effective, or if later the expiration of the previous extension period, whereas subsection C regarding the extension of a designation is simply is extended. It doesn't say 60 days later, et cetera.
That's correct, Your Honor. The extension is effective immediately. The other point I'll make is that the TPS holders who are covered under the 2023 extension, my friend opposing counsel said that they knew their TPS would end on April 2nd. That's not correct. They knew that a new decision was required within 60 days before April 2nd, and they knew what conditions in Venezuela were. And so they knew a new decision would be coming, but they weren't anticipating. There wasn't a termination of Venezuela that was set to take effect at that time.
All right. What about the other argument that there was not a termination, this was a vacator?
First, Your Honor, under Gorbach, the en banc Ninth Circuit decision in Gorbach and China Unicom just a few months ago, as Your Honor stated, where a statute provides a specific process to alter an authorization, here the designation, that negates an assertion of
I'm sorry, say it again.
Where a statute provides a specific process to alter the designation, that negates an assertion of implied agency authority. I just also mentioned that, as Your Honor mentioned, neither of those cases discuss the TPS statute, but Gorbach does address one other statutory provision the government points to, which is 8 U.S.C. 1103A, the sort of broad enabling statute that sets forth the Secretary's powers and responsibilities. And they say that that is not a source of implicit reconsideration authority, and that because in Gorbach, the question was whether the Attorney General had authority to denaturalize a person where she had evidence that the naturalization was based on a fraud or material misrepresentation, and the court said no, because the statute sets forth a process for denaturalization, and that exhausts the field. Similarly here, Your Honor, the TPS statute has a process for altering a TPS designation, and that's inconsistent. That process is inconsistent with an assertion of implicit authority to reconsider. And the fixed time period also is another
When you say
separate factor.
the process, that's the process for the periodic review?
Yes, Your Honor, the process in subsection B3 of the statute, the periodic review. It says when the decision has to be made. It requires consultation. It says how and when the decision has to be published. It says the bases, the permissible bases for a decision. And it says what the options are, and the options are to extend or to terminate, Your Honor. There is no vacatur. Under Gorbach and China Unicom, that process exhausts the field, and that process negates an assertion of implied agency reconsideration authority. We also cite, Your Honor, a DC Circuit case that involves a similar statutory scheme from 2023. It's NRDC versus Reagan. That was a case that addressed whether the EPA had authority to reconsider its determination that a certain contaminant in drinking water should be regulated. It's similar because the EPA there had a lot of discretion at the outset to determine whether regulation was appropriate. But once it made that determination, it triggered certain things under the statute. And so the court held to allow the EPA to reconsider its determination, just wipe it from the books, contravene the statute, because under the statute, the determination triggered, certain things flowed from that. The same with the TPS statute, Your Honor. Secretary Mayorkas's determination that conditions for the designation continued to be met triggered an extension, and under the statute, TPS could not be terminated before the expiration date for that extension. So to allow the vacatur here would contravene both those protections in the statute.
And what's your response to the argument? We're going to need to take a break here in a moment because the court reporter's been going at it. But what's your response to the need, if an emergency arises, a national emergency arises, that the government and the secretary needs flexibility, and that's why one should imply some additional authority beyond that that's prescribed in the TPS statute? What's your response to that?
A few things, Your Honor. One is that Congress has provided a means in the TPS statute for the secretary to address national security issues. And it is not to vacate a TPS extension for 600,000 people. Under subsection C2B, if the secretary determines there are reasonable grounds to regard an individual as a danger to the security of the United States, that individual is not eligible for TPS, and that individual's TPS may be withdrawn. That's the mechanism Congress has provided to the secretary. The second point I would say, Your Honor, is that if you look at the vacatur and the government's arguments in the brief, the vacatur, as you noted, is based on alleged problems with the filing process. Vacatur is not based on national security issues. And the last point I'd make, Your Honor, is that China Unicom, which sets forth this rule that where the statute has a specific procedure that exhausts the field, that's a case where the agency was asserting reconsideration authority based on national security grounds. And so there's not a different rule in that context. Even if the agency is asserting national security or some other important interest, they still have to follow the law.
All right, let me give you a brief chance, and then we're going to take a break, and I want to continue after we give the court reporter a chance. Here.
Sure, Your Honor. I do want to go back and note that the extension itself explicitly says that it doesn't go into effect until April 3rd, 2025. So I understand plaintiffs would like for it to have gone into effect immediately, but the language itself in the FRN explicitly gives the effective date. And just because it allows people to re-register, that makes sense as a practical matter so that there would be no break in their employment authorization documents.
What does effective date mean? Doesn't that mean that because there was already a designation extension that this
Correct.
becomes, it doesn't mean that it doesn't have any operative effect?
It has operative effect, but it's not going to do anything until April 3rd. People can re-register and they can have their employment documents teed up so that they can continue working, but that extension, it doesn't go into effect until April 3rd.
So you're saying that at the very least, the secretary has the ability to vacate an action if it's not in effect at the time of the vacatur?
Yes, Your Honor.
And is there a case law that draws that distinction, that keys it to the effective date?
Not that I'm aware of, but that is also what Secretary Mayorkas relied upon when he vacated the termination decisions. I would also point out that it is contrary to the statute to say that a secretary cannot come in and look and determine if there's a national interest concern.
Well, it can, but it does so in the process of designating, whether or not a TPS status is warranted under subsection C.
Well, and different administrations are permitted to come in with different goals and different policies as long as they're within the confines of the statute. And here, the statute provides a periodic review. So the idea that the secretary would have to wait a year and a half before she could make what she feels is a concerning decision on the national interest of the United States is contrary to what the language of the statute itself says.
Well, I'm not so sure about that. The language of the statute says, even considering where TPS status is granted in part because of concerns about national interests. By the way, it says national interests. I'm not sure how that's different from national security, but national interests of the United States.
Yes.
It still says that to terminate, you've got to follow 3B. And there was no exception to say, well, if the designation is made under B1C in the national interests and that can be advanced or something. There's nothing that says that.
I'm sorry, could you say that again?
Nothing in the statute allows an advancement of the termination right where the designation is based on B1C, national interests. It makes no distinction. It just says you've got to do it, during these periodic reviews, et cetera, et cetera.
Correct, Your Honor. That's why we argued that it's inherent in the statute. It's not explicit in the statute.
All right. When we come back, I do want to address the reasons for the vacator and the question of whether there's a review of that, assuming that that there is authority to vacate. I think the secondary argument is that it was still wrongful to do it. Obviously, if I were to find as a matter of statutory construction that there was no power, we don't need to reach that question. And then I do want to address the equal protection matter. So we'll take a 15-minute break for our reporter who's been going at it. Thank you.
Court is in recess.
Los venezolanos y a los venezolanos no sé, allá en Estados Unidos.
Señores, aquí vamos a quedarnos aquí, vamos a esperar a ver cuál es la decisión que van a tomar. Yo pienso que de manera particular lo van a entender, Usted verá que sí, así que tranquilo. Vamos a ver, vamos a responder preguntas. Ahí se ve, la señora se ve un poco asustada, al parecer no se preparó bien y se la están comiendo. Vamos a ver qué va a pasar. Yo pienso que vamos a ganar y que esto va a beneficiar a todos. Vamos a seguir compartiendo, vamos a esperar estos 15 minutos de receso. No olvide continuar compartiendo la transmisión. Dice por aquí, doctor Juan Carlos Llanes Olivero, observa juez receptivo escuchando argumentos. Sí, así mismo él está muy receptivo y pienso que los defensores de la parte venezolana se lo están comiendo porque está un poco asustada la joven. Pienso que ella no se preparó, no conoce bien el tema. Y por eso hasta con la fecha se equivoca. Así que así es, Paulina. Vamos todos a cruzar los dedos. Vamos a pensar que sí, que todo va a salir bien. Vamos a mantenernos aquí, señores, no nos vamos a ir de la transmisión. Vamos a mantenernos en la expectativa. Señores, denle like a la transmisión para que esto llegue a más personas. Vamos a darle like todos. María Carolina, así mismo, mente positiva. Como dicen por ahí, mente a nada. Ahora el juez va a tomarse un café tranquilo. Él va a consultarlo con su equipo. Y de allá saldrá una decisión que pienso yo será una decisión positiva. Pues hay demasiada esperanza en este día de hoy. Demasiada angustia se ha causado en estos últimos días. La verdad que así será. Dice José Jiménez que ¿quién está nerviosa? ¿Ellos o nosotros? Quienes están nerviosos son ellos, pues si observa la forma como se maneja la abogada del gobierno, ella se nota insegura, como si no estuviera preparada. Yo voy un poquito más lejos. Yo pienso que ella está ahí porque es su trabajo, pero a lo mejor ella no está haciendo su mejor trabajo para que de alguna manera puedan darle esta parte del beneficio a los venezolanos. Pienso que ella en realidad está del lado de nosotros. Dice, soy de Nicaragua, estamos con Venezuela. Todos estamos, señores, con Venezuela, porque hoy es con Venezuela, mañana será con El Salvador y todo día será con alguien nuevo. Pues la idea es tratar de sacar a todo aquel que no entró de manera organizada. Dice José Enríquez Ortiz, es un beneficio para todos los latinos. Si eliminan buscarán eliminar todos los TPS. Es así como usted le dice, José Enrique, eliminarán uno por uno todos los TPS. Estamos en el receso, tenemos 15 minutos de receso para continuar con la audiencia, así que no se desconecten de la transmisión. Vamos todos a darle like, vamos a compartir la transmisión. Dice por aquí Malta Cena, todo lo puedo en Cristo que me fortalece. Así es, todos unidos, señores, somos más. La unión hace la fuerza. Muchos quizás se pueden alegrar de que hayan quitado esos beneficios, muchos lo hacen quizás por envidia y otros lo hacen por recelo, pero lo que no entienden es que hoy puede pasarle a un grupo y mañana le va a pasar a otro. Dice Gina, líder del parol humanitario aún tienen chance de someter asilo. Eso depende de si no ha pasado el año. Ahora, si usted leyó el memorando que tiene el memorando completo en la 35 páginas que ellos emitieron, hay una parte en esa página que habla claro de la cantidad de asilos afirmativos que se sometieron de todo aquello que entraron con el paro humanitario. Así que mantengámonos aquí tranquilos, vamos a ver lo que va a pasar. Yo pienso que lo que va a suceder será positivo y evidentemente se podrá continuar. Todos unidos. No entiendo a la muchacha que se traba, está del lado del gobierno o de Venezuela. La que se está trabajando está del lado del gobierno. Esa es la abogada del gobierno. Esa es la del gobierno americano. La de nosotros, la parte de defensor, está activa, dura. Esa está dura. Carmen Garata, ¿cómo está? Carmen, estamos en receso por ahora. En 15 minutos el juez regresa. Me parece que va a tomar una decisión positiva, pues le está escuchando tranquilamente. Walter, dice Walter. Vamos a ver qué dice Walter por aquí. El TPS El Salvador no lo va a quitar a pesar de no ser necesario por arreglos corruptos con ¿quién? Con Nayib Bukele. Ok. Eso es. Vamos a ver, señores, uno en realidad nadie sabe lo que va a suceder. Vamos a esperar la decisión del juez, que vamos a esperar que sea una decisión positiva para aquellos que estamos apostando para que este proceso sea positivo para nosotros, señores. Estamos en eso. Vamos a compartir todo esta transmisión. Vamos a compartir. Dice, yo pienso igual que ella no está defendiendo mucho con el fin de que lo extienda. Yo también pienso lo mismo porque es más fácil que le den el beneficio y que ella se vea que ella está haciendo su trabajo, pero al final de la jornada ella entiende que es una decisión arbitraria y que va a perjudicar demasiadas familias, señores. Todos estos programas humanitarios han venido a ayudar a familias completas y es un daño lo que se va a hacer. Y pienso que en la unión está la fuerza. Señores, los latinos, nosotros, todos somos uno. Yo recuerdo en los años 90, 80, cuando todos los dominicanos emigraban hacia Venezuela para tener mejor vida y vivir mejor. Y hoy está esa situación difícil en Venezuela, pero puede pasarle a cualquiera. Hoy es Venezuela, mañana puede ser otro país que venga con un dictador como lo es el presidente Maduro. Puede pasarle a cualquiera, señores. Dice, la redacción argumenta en función de la discreción que tiene mayoría de revisar y aprobar la decisión de terminal. Vamos a ver qué dice Global Migratory. Dice aquí que las razones esgrimidas por la administración de determinar el TPS por seguridad nacional no es pertinente, ya que el Congreso ha establecido un proceso para la revisión del TPS. Muy buen planteamiento, líder suyo. Excelente planteamiento. Dice María Núñez. Vamos a ver qué dice María Núñez. ¿Qué piensan ustedes que va a pasar en el día? Déjenme en los comentarios para ver qué va a suceder. Vamos a ver qué va a suceder en el día de hoy. Ya están casi vienen entrando para la sala. Ya están comenzando a entrar. Dice María, fe y fuerza, líder, Dios está guiando a nuestros abogados, defensores, y le da sabiduría al juez. Totalmente de acuerdo, señores. En un par de minutos comenzamos, pues ya están comenzando a entrar en la sala. Solamente la abogada de la defensa del gobierno se mantiene sentada en la sala. Aquí estamos, señores. Vamos todos a darle like. Vamos a darle like a la transmisión. No veo like. Vamos a darle like todo. Vamos a compartir. Dice Global Migration Server. Ojo, no es mi opinión. Estoy repitiendo lo que argumenta la representación de la peticionante. Bueno, es su opinión, líder. Cualquier opinión cuenta. Así que tranquilo, que todo esto será positivo, todo positivo. Señores, existe la energía positiva y pienso que entre todos unidos somos más, como dicen por ahí. Vamos a darle like a todo. Estoy escuchando la audiencia y repitiendo. Excelente, excelente. La representación de la peticionante es muy preparada. Puede que sea muy preparada, pero está ahí dando rienda suelta para ver qué pasa. Ahora, señores, viene lo bueno. Sí, ahora que viene lo bueno, porque ahora ya están entrando a la sala, ya están comenzando a entrar a la sala, ya se están organizando. Vamos a presentarle aquí la pantalla. Vamos todos a compartir. Vamos a darle like a la transmisión y poder ver en manera en vivo, señores. Aquí estamos en vivo en la audiencia sobre el TPS para Venezuela. Dice María Núñez que la justicia privada nos merecemos esta oportunidad y que quede presente para nuestros países hermanos que tengan TPS. Ojalá y que esto sea una jurisprudencia positiva para todo lo que se encuentran bajo estos programas. Dice, ahora el juez pidió que al regresar lo expliquen sobre la defensa específica planteada, que el Ejecutivo tiene discreción de aprobar la respuesta de vela, demostrar por qué no la tiene. Sí, de velar, porque eso es cierto. Vamos todos, señores, vamos a darle like a esta transmisión, vamos a compartir. Déjenos sus opiniones para saber qué usted opina que sucederá en breve momento con la decisión del juez. Dice Danilo que decidió el juez todavía no ha decidido, ya el juez viene en breve momento. Hubo un receso de 15 minutos y bueno, ya en breve momento estará por aquí, en breve momento. Ya están entrando a la sala, ya entró la secretaria del juez. Señores, ya están entrando. Vamos a ver qué va a pasar en breve momento. No se desesperen. Vamos a compartir la transmisión para que pueda verlo más personas. Vamos a compartir, vamos a dar like. Vamos a darle like, señores. Y ahora viene... Ya entraron, bueno, los litigantes están entrando, solamente faltaría que entre nuestro honorable juez Edward Chinch. Que Dios le dé sabiduría a la defensa para que cada palabra que salga de su boca llegue al corazón del juez. Y que sea la ley de Dios que triunfe, que viva Dios el que decida nuestro futuro y no el hombre. Amén. Que así sea. Denle like, denle like, señor. De verdad, señores, denle like. Y si usted no está suscrito al canal, vamos todos a suscribirse al canal. Vamos a suscribirse. Ya le di like, lo compartí a todo el mundo. Muchísimas gracias por compartir. Dice, vamos a ver todos los comentarios que tienen por ahí. Tienen por aquí los comentarios de lo que ha dicho, si van cosas positivas o no. Van muchas cosas positivas. Señores, vamos a compartir la transmisión. La segunda que habló, dicen aquí, la segunda que habló lo hizo con mejor actitud. El juez está indagando sus alegatos. Eso es correcto, señores, eso es correcto. En breve momento tendremos a nuestro honorable juez en la sala, lleno de sabiduría y sobre todo que esto, bueno, ya estamos entrando, señores. Vamos entrando. Dice Paulina, claro que sí, lo lograremos, gracias al líder y a todos los que están acá, de otras naciones, apoyando en nuestro país, Venezuela. Claro, Paulina, tenemos que apoyar porque todos los latinos somos uno, somos todos uno. En realidad estamos unidos todos los latinos por Venezuela. Hoy por Venezuela, mañana por Cuba. Señores, acaba de entrar nuestro honorable juez. Vamos a prestar todo atención.
All right, thank you, everyone. Please have a seat.
Vamos todos, señores, vamos a compartir la transmisión.
Okay.
No olviden
I want to address the question, if we assume that there was the power to reconsider and issue a vacator, then the next question is there a review over that decision? And if so, was there a problem with that decision such that a stay of that vacator or not stay, but a postponement of that vacator is warranted? So the first question again, we revisit the question of whether the decision to vacate the extension is reviewable. And I guess I start with the same sort of point that if you look at the factors that the court considers, you look at whether, how much of this was based on individual analysis, individual records, how much was based on examining things that are within the agency's expertise, such as examining country conditions and assessing reports from the State Department, from various agencies, or is it more procedural? And it does seem here that the reasons for the vacatur, I don't know how to pronounce that word. I'll call it vacatur because it's easier. Whether that is something that is more collateral than sort of central to what the statute, to what Section 1252 is about, or 1254B5A or B is about. And so again, I'll turn to the government. It does seem to me that these were not decisions based on an assessment of country conditions, based on foreign relations and this sort of thing, but really kind of looking at procedurally whether Secretary Mayorkas essentially screwed up and caused confusion, did something in violation of the TPS statute, created a sort of procedural problem that needed to be fixed. Putting aside the merits of that, isn't that the kind of thing that is not necessarily within the agency's expertise and doesn't depend on the records of individual TPS beneficiaries or specific facts about the country? It could have been any country. I mean, it didn't have to be about Venezuela. It could have been, if he had done the same thing with Haiti or El Salvador, I mean, the same arguments would be made. So it doesn't seem to be even related to the country. It's more about the process. Isn't that the kind of thing that is reviewable?
No, Your Honor.
Okay. All right. Tell me why.
Looking at the vacated decision from Ramos v. Wolf, the Ninth Circuit talks about the merits of these decisions, and those merits aren't reviewable. And here, looking at registration, that's a discretionary function of the statute. The statute gives the secretary the discretion to determine how registration takes place and when. And so plaintiffs are correct that that these overlapping registrations can take place, but that's within the discretion of the secretary on how that registration should take place. So here, the secretary herself has that knowledge and that ability. The statute gives her that ability to determine whether or not, in her discretion, she thinks that this is the way that the registration should be taking place. And she uses that to decide to vacate the decision extending TPS for Venezuela. And if you're looking for the statutes that I'm discussing, it's 1154A C 1A subromanet 4, which says, to the extent and in a manner which the secretary establishes the alien registers for temporary protected status under this section during registration period. And I believe there's another, the period of validity is subsection D2. The Attorney General may stagger the periods of validity of documentation and authorization. So both of those statutes are discretionary in how the secretary sets up the registration periods.
So it's funny, it depends who's arguing what. To the extent that there's an argument that any secretary, including Secretary Mayorkas, had the ability to determine the manner of registration and to stagger periods, et cetera, there's an argument that that was committed to his discretion in his initial, but then you're saying that if vacator revisiting is within the inherent power of the next secretary, she also has the same power exercise her discretion and changing the manner of registration, et cetera, et cetera.
That's correct. And I go back to the statement that I made before that the Supreme Court has recognized a couple times that it's hardly improper for an agency to come in and change their policy preferences and ideas and work within the confines of the statute to make those changes. And that's Motor Vehicles Manufacturers Association, where Rehnquist was concurring, and also Department of Commerce v. New York, where the Supreme Court made that same statement. So here, it's true that she doesn't make an analysis of the country conditions, but she does make an analysis under the statute of how the statute should operate. And again, that vacatur permitted her to then have space to look at the national interest of the United States and the factors on the ground and determine.
But wouldn't that argue that, I don't see why you couldn't have judicial review, but that judicial review might be deferential if there's some discretion committed to the agency. It doesn't mean there's no review. I mean.
Well, the statute does say any determination relating to.
But it's not a determinate, if we go back to what determination means, and at least as has been opined in the now vacated Ramos decision, but which drew, some support from McNary and other cases, there is some framework for determining what is a quote determination and what's collateral, what's procedural. This still sounds very procedural. I mean, how are you going to do the registration, whether you stagger them, et cetera, et cetera. It's not, are conditions really, adverse in a particular country. So it still sounds like the kind of thing that's not within the term determination as used by the TPS statute.
And to that, I respond that when looking at McNary, it was a determination and it was of an application, whereas this is any determination, which in Patel, the Supreme Court recognized under a different statute, but any judgment regarding there were a couple provisions that the judgments were regarding. And using that any, they found that any broadened what those judgments were. It wasn't just the final judgment itself, it was the factual underpinnings.
All right, let me hear the response to that. That with respect to whether or not there should be judicial review, that should be informed by the kind of discretion as to the how and the manner and the extent language of C1 Romanet 4 and D2.
Yes, Your Honor, and just to be clear, I'm discussing jurisdiction. Ms. Banta will discuss the merits. I realize they're bleeding a little bit, but we'll switch over here in a minute.
Okay.
If, with the court's permission, I just want to mention two things briefly before I answer that question. One is that on the question of whether the January 17 extension went into effect or not, I just want to point out in this record already, there's evidence that two of the plaintiffs, Freddy Rivas and Mariela Gonzalez, both already got a extension for employment authorization of 540 days under the January 17 extension. And I'm sure they're not the only ones. And I think what that shows is that effective date is a reference to when the 18-month period starts. But it obviously doesn't mean that the extension wasn't in operation yet. And for them, the reliance interest is very real, right? Like they are holding a document, they're still holding it today, which says, I can work in this country for the next 540 days. And now they're saying, the government is saying that document
Él está poniendo ahí
is
una
actually invalid.
comparación de dos personas
So just on that.
que
All right, so it's operative, whether you call it
tenían
ineffective,
su
it was actually
permiso de
operative.
trabajo
Exactly.
con
Now,
la medida
the second just preliminary point I want to make is we're all talking about these jurisdictional issues as though the Ramos panel majority decision were correct, which sort of makes sense of their concession on the vacatur authority point, because the court held that a claim that the agency has adopted an erroneous interpretation of the statute is reviewable under a McNary, because the analysis goes to the review of the law itself and not the determination. I understand that's the distinction Your Honor is drawing now. But I just want to put a pin in the fact that if it ever comes to, down the line, our view is that Your Honor's decision and also the dissent from Judge Kristen is a better reading of the jurisdiction stripping statute. I don't think it actually matters for either claim, which I'll get to in a second, but I just want to put a pin in that. We're not conceding it. The reason why the second claim is reviewable is actually for a reason that was not discussed at all in Ramos, in any of the opinions in Ramos. And that's because
When you say the second claim,
I mean the challenge, our challenge to the reasons given for the vacatur.
Yep.
It's because the statute says there's no judicial review of any determination with respect to designation, termination, under this subsection. And under this subsection, that's subsection B of the statute, which is what has all the rules for designations, terminations, and extensions. And that doesn't apply to our claim on the merits of the vacatur for two reasons. First, vacatur is not one of these things. You know, it lists the three things: designation, termination, extension. It doesn't say vacatur. Obviously, that dovetails with our merits claim that there is no vacatur. But as far as just construing the jurisdictional statute, does it bar determinations made in vacatures? No, because it doesn't say vacatur in it. And the second reason why, Your Honor, is because the defects that the Secretary pointed to have to do with the registration process. And as Your Honor was just noting, I think the government said today that Secretary Mayorkas could have had the discretion, did have the discretion to set up whatever registration period he wanted. And then there's some back and forth about that. But either way, what you're talking about is the registration process. And the registration process is discussed not in this subsection.
El
It's not in
secretario
subsection.
Mallorca tenía la
in
autoridad
subsection
para
C.
extender el TPS.
And so this stripping provision does not cover
Vamos a
determinations
compartir, señores,
that
vamos a dar
have
live,
to do with the
vamos a
registration
compartir.
process. The registration process is in a different subsection of the statute. And so regardless of these other distinctions that were drawn and, you know, what is collateral and what's direct and all of that, the subject matter of the stripping provision is focused on country conditions, on the things that are at the core of whether you decide, when the Secretary decides, am I going to extend or am I going to terminate? These registration issues are totally different. They have to do with how you administer the statute. Once you've decided you are going to extend, then you have to set rules for how you let people register. And that part, Congress did not mean to strip. So our interpretation of the statute is that any APA claim that has to do with registration is cognizable because the statute didn't strip it. And our claim on the merits, Your Honor, is that, I'm just going to describe it, I'm not going to defend it, but the claim on the merits is that the reasons that the Secretary gave for why she had to vacate this are arbitrary in violation of the APA. She said that there was something wrong with consolidating the registration period, which I think is the opposite of what Ms. Wong said today. She seemed to be saying today there's nothing wrong with it. You know, but either way, our position is that it was wrong. It was wrong to say that there's something wrong, that there's something illegal or untoward or odd about consolidating registration process. You know, Ms. Banzo will talk about the merits, but whether we're right or wrong about that, that's what our claim has to do with. Our claim has to do with the validity of the reasons that she gave for attacking the extension, and the reasons she gave had to do with this dispute about whether you can consolidate them or not. So that is not within the terms of the stripping statute.
well, let me ask you, with respect to the stripping statute, and your point about it pertains, 5A only pertains to designation, termination, or extension of a designation, and not vacatur. So you're not making the argument that the vacatur here was in effect a de facto termination.
It definitely had the effect of taking away the extension, but it is not a termination. I mean, it's not styled as a termination. She said, oh, we're going to make that decision later. And then 3 days later, then they issued the termination.
Right. So there's not a literal violation of the statute which sets forth this process and effective date of any, quote, termination, but it's an argument for statutory construction.
Well, I mean, our merits argument is that any action, however you style it, that shortens the period of an extension after the extension has been made is a violation of the statute. But the way in which they did it, so our argument is it is definitely functioning to shorten an extension, which is a violation of the statute. But the document in which they did it is not an extension. They're saying that there's a separate kind of document not mentioned in the statute called a vacatur that we have implicit authority to do, even though it's not mentioned here. And my point is, obviously, we don't think that's true on the merits, but my point is, if you say that there's extra statutory implicit authority in the common law of agency decision-making to do these vacatures, well, then where in the stripping statute does it say that a court can't review what's inside those things? And it doesn't say that.
Well, because if you equate the functional equivalent of termination with vacatur, then I mean, you sort of have to, it's a thin line. For one purpose, you're saying they're kind of the same, they're functionally the same. For another purpose, you're saying, well, the statute doesn't use that terminology, so they're different.
Yes, I think what I would, how I would try and draw the line is I would say a vacatur is a vacatur that has the effect of shortening an extension is unlawful. But the reason it's unlawful is because it violates this provision of the statute, which says that extensions, what Ms. Bansal was talking about, extensions are effective or last until the end of the time. The government's argument for why the stripping statute covers this is based on this hyper literal reading of this statute. They say it's any and not a. They say with respect to, not regarding or something. And I'm saying if you're going to take that seriously and ignore McNary, ignore the mountain of Ninth Circuit cases that treat determination as a term of art and just focus on the words. My question is, where in the statute does it say that the court has no authority to review a vacatur, any argument, any determination in a vacatur? And it doesn't.
All right.
I should say also, I heard them to concede that statutory claims are reviewable, which is what the two judges in the Ramos majority thought as well. So I think it sounds like we're all in agreement about that. But I'm saying this because it's relevant to our second claim as well. I think any claim involving a vacatur, even if it would otherwise not be collateral, should be reviewable because vacatures are not mentioned in the statute.
All right, so let's talk about if I were to find reviewable, first of all, that there is authority to do vacatur, and second of all, that it is reviewable. What about the merits? Is it arbitrary and capricious here?
Thank you, Your Honor.
And
El juez está
one
siendo
of the
friendly.
reasons is that the sort of the criticism of allowing an extension or subsequent designation to sort of subsume earlier ones is somehow inappropriate, but that that's done all the time. Every time you redesignate, there is some subsumption going on.
That's correct, Your Honor. So in the 35-year history of the program, there have been approximately 36 redesignations, and each subsumed an earlier designation. That's the purpose of a redesignation, is to expand the pool of eligible beneficiaries. So under the statute, to be eligible for TPS in subsection C, you have to show that you've been continuously physically present since the most recent extension of your country. And so when a country is redesignated, that date gets pushed up. So for Venezuela to qualify under the 2021 designation, an applicant had to show they've been continuously here in this country since March 2021. Then when Venezuela is redesignated in October 2023, that date moves up. So you have to show continuous physical presence since October 2023. Everyone who qualified under 2021 qualifies also under 2023. So in that sense, a redesignation always subsumes the earlier designation. It's also standard following a redesignation that the filing process to re-register is the same for any applicant who has TPS under that country, regardless of when they first registered. So the example we give in our brief, and and there's many, Your Honor, but Sudan
De la joven
was
es
first designated for
importante.
TPS in
Ella
1997.
dice que
It
si
was redesignated
tiene
several
residencia
times,
continua
including in 2013.
y se te va a vencer
Following the
3 veces, que
redesignation, there
simplemente
aren't
de
two
haberlo
separate
extendido,
re-registration
eso
processes. Everybody
significa que no
re-registers
tenía
together.
que registrarse de nuevo. Así que Mallorca tenía razón. Vamos
So
todos,
there's
señores, a
nothing extraordinary
compartir.
about what happened here.
There's nothing extraordinary about what happened, and I believe the government just acknowledged that. They said the secretary has discretion to consolidate filing processes. And so Secretary Noem's statement that Secretary Mayorkas's consolidation was somehow novel or inconsistent with the statute demonstrates her own misunderstanding, Your Honor, because all this, it's not novel because it happens all the time. And all the statute says about registration is that you have to register, this is at C1A, to the extent and in a manner which the secretary establishes. So I don't understand how it could possibly be inconsistent with the statute, Your Honor. Secretary Noem doesn't explain in the Federal Register notice, and defendants didn't explain in their opposition how it could be inconsistent given that all the statute says is register the way the secretary tells you to.
What about the fact that the January 17th extension, it extended the 2023 designation, correct? But also had the effect of extending for the 2021?
That's what Secretary Noem said. I don't think that's correct, Your Honor. I think that Secretary Noem was conflating an individual's eligibility for TPS with a country designation. So Venezuela's 2021 designation still expires. I mean, the expiration of the current extension is September 10th, 2025, and there will have to be a new decision 60 days before that. What Secretary Mayorkas did was say, well, if you, an individual, first registered under the 2021 designation, I recognize that you also qualify under the 2023 designation because you meet that, you've been continuously here in this country for longer even than you needed to be. And so you can re-register under this 2023 extension, and you, individual, may extend your TPS status because you qualify. You are eligible under both extensions.
So if you don't register under the 2023 extension, you're still subject to the September 25 expiration.
That's correct, Your Honor.
But the effect of the 2023 extension was to allow that registration for the 2021, effectively allowing an extension for them from September 25 to October 26.
It allowed those individuals who had first registered in 2021 to receive an extension through October 2026. That's correct.
And could that have been done as a separate document other than not just extending the 2023, but expressly extending for those who are coming up in 2025?
So I do think it's a separate question, but if the question is whether Secretary Mayorkas could have extended the 2021 country designation, is that,
Yeah.
The statute requires that the secretary make a decision at least 60 days before the expiration. It doesn't set, a point at which it's too early to make a
As
decision.
long as it's 60 days or earlier.
Right.
And it's effective upon, as we talked about earlier, once that determination is made, that the country still qualifies.
That's correct, Your Honor. And we cite in our brief examples where, countries' decisions have been made as much as 159, 102 days earlier, but that's not, Secretary Mayorkas did not extend the 2021 designation. He didn't make that decision in January. What he did was extend the 2023 designation and just acknowledge that the individuals who had first applied in 2021 were also eligible. They met all the criteria to obtain TPS under the 2023 designation too, and so he permitted them to re-register.
So how's that different from an actual express extension of the 2021 designation?
Because, Your Honor, the individuals who had TPS under 2021, if they chose not to re-register under the extension, then their documents expire September 10th, 2025. They would still be on that other track. So they could choose to switch tracks, but the two tracks still exist.
And had the extension been granted, and an express extension been granted, then there would be no need to re-register under the 2023, that everybody under the 2021 would be, that's what I'm trying to figure. What's the operational difference?
It's just whether or not there's two separate tracks with two separate timelines, Your Honor. And the two separate tracks, so if 2021 had been extended,
Yes.
2021 folks would still have had to re-register, but their documents would expire on a different date. So say Secretary Mayorkas had extended the 2021 designation 18 months also. That 18 months would run from September 10th rather than
Or he could have
April 2nd.
extended it to the exact same date as a 23 extension.
He could have tried to make them line up.
So had he done that, would there be any operational difference between doing two separate ones as one designees?
Only, Your Honor, that the extension can only be 6, 12, or 18 months. And so I'm not sure mathematically if he could make them line up exactly.
Oh, you can't choose anything in between.
No, yo lo pregunto de donde se conoce, porque ya lo que está en el donde se conoce. Le pregunté por eso. Señores, la transmisión se acaba de caer. Vamos a entrar de nuevo. Vamos a entrar de nuevo para... Estamos tratando de entrar de nuevo. Nuevo, nos sacaron de la transmisión a conectar, así que
To get off the 2010 track and sign up on the 2022 track because they all qualify. So it's not, this is not the first time this has happened, is what.
And does the statute or is there any regulation addressing this two-track that authorizes this?
No, Your Honor, there's nothing in the statute that explicitly addresses it, and there's nothing in the statute that prohibits it. With respect to the individual registration, subsection D2 of the statute, as Your Honor pointed out recently, explicitly allows the secretary to stagger the validity periods of individuals' TPS authorization documents. So that also supports Secretary Mayorkas's ability to allow people from, who initially registered under one designation to re-register.
Ya estamos conectados de nuevo.
re-registration pursuant to the Secretary's USCIS's instructions.
And so is your response to the concern of Secretary Nome that what Secretary
Aquí estamos,
Mayorkas
señor.
had done was contrary? And she wants to fix it. What's wrong with that?
So we're only reaching this claim if the court were to find that there is some implicit authority in the TPS statute that allows for reconsideration.
Yeah, no, I know that.
And the courts have said that that implicit authority can extend to correcting an inadvertent clerical error. So this is the Supreme Court in the American trucking case that we cite in our brief. But it can't be used as a guise to change a decision just because you want it policy. So even where an agency has implied reconsideration authority, that authority is not listed.
So you're saying that that reconsideration is limited to fixing clerical errors?
Yes, Your Honor.
And
Implied
not,
authority. And they express that reconsideration merely to change your mind is disfavored, and they will not read implicit authority in a statute to authorize that type of reconsideration.
well, one of the counter arguments, besides whether that reconsideration, if it is allowed at all, is so limited, it's not just merely changing mind on policy, but clearing up confusion.
Was confusing. The obvious solution is to deconsolidate, not to vacate the entire extension.
So, and what would happen with deconsolidation? Then each would be on their own tracks again? The 21 people would be back to the September expiration?
That would be one possibility, Your Honor, yes. And the Supreme Court in DHS versus Regents, drawing on motor vehicle manufacturers versus State Farm, says that if an agency is rescinding a prior policy, it has to consider alternatives that are within the ambit of that policy. And so, for example, in Regents, the court was evaluating the Secretary's termination of the DACA program. The reason she gave was that the work authorization and other benefits provided by DACA were potentially unlawful. And the court said, okay, but there's a whole nother part of DACA, which is protection against deportation, and it's arbitrary and capricious to rescind the whole program without considering whether you could maintain that portion. And so if Your Honor were to find that the Secretary did give a reasoned explanation that the consolidation was somehow confusing, the obvious solution would be to deconsolidate, not to vacate the entire extension.
All right, thank you. Let me hear from the government.
If I could, I do want to go back to just something counsel said regarding the jurisdictional claim and saying that this is a hyperliteral interpretation of the statute. That's the Supreme Court that has taken that interpretation. So it is what the court has told us that we are supposed to be looking at these words and how we're supposed to be interpreting these words. As to whether or not, as to the text of the vacatur, the reasons for the vacatur were, as Your Honor noted, it's the novel approach of combining two separate designations into one that had previously been on two separate tracks. Typically, when a secretary designates or redesignates, they do it at the same time. And so the tracks flow together. Whereas here, by having the October 2023 redesignation, that created a separate track, and we have two sets of individuals and who are covered by temporary protected status, but with different end dates. So because
there were two different tracks with different end dates.
Yes.
And the effect of this consolidation is to allow people to use the same end date, right?
Correct. And thereby over not making a determination on the 2021 designation as an extension.
You mean, so what was absent is an express determination on the 2021 country designation?
Correct. Instead allowing the
But is that sort of obvious? The same findings that apply to the extension of the 2023, which made country considerations findings. I don't know how you could have two different ones. I mean, how could they diverge?
That's true, but the statute does say, I mean, we're here discussing what the statute says, and a decision on each designation shall be made. Once the initial designation is made, the periodic review kicks in. And so by subsuming that 2021 designation underneath the 2023 redesignation, individuals would then obtain, I think, an extra 13 months of TPS status by rolling into the 2023. So that is the novel interpretation that Secretary Noem is discussing in the vacatur. But she also does state that not only is she looking at this novel approach with the extensions and designations, but she notes that she would like that the vacatur provides her an opportunity for informed determinations regarding the TPS designations and clear guidance, which refers to the President's executive order. So it's not just the re-registrations and the conflating the two extensions. It's also to look at how these designations have been implemented and the underlying legal grounds for those implementations.
You mean to revisit the actual designations, that not just how they're implemented, but the actual designations, taking issue with that.
Yes. Plaintiff's approach would never allow a secretary to revisit a designation, no matter what changes within the interior or the exterior of the country. And these are foreign policy, these are national, I mean, here it's a national interest determination, which is a very broad determination.
Then that goes back to the question whether there's authority to revisit on those substantive determinations, those substantive designation determinations.
Yes, Your Honor, everything is tied up together. To the point of whether or not the secretary can reconsider the decision, this is also something we've already discussed, in that Secretary Mayorkas took the same approach and disagreed with how evidence was weighed and vacated the terminations in order to create extensions, to extend either extend or redesignate, depending on the country.
What about the argument about if there was some confusion, that the obvious answer was to look to alternatives, it would have been deconsolidation rather than entire vacation or vacatur?
I think that goes back to the reasons behind the vacatur, which again is because Secretary Noem explicitly says that she wants to relook at these determinations. And so it's not just tied to the approach of subsuming the 2021 extension into the redesignation. She also would like the opportunity to look at those determinations.
Including the 2023 extension?
Yes, yes.
So that was a real driving force. It wasn't just confusion in registration. So let's put it back the way it was. Allow the 2023 extension in place and take the 2021 people out and put them back to where they were. Is really to look at the whole designation.
The whole scheme and whether or not the designation complies with the statute.
But the designation in terms of whether or not it was warranted to redesignate Venezuela as a designee country.
Yes, Your Honor.
Okay, and then the response to that is that, well, there's no power to do that, but I guess that puts us back in the old first statutory question.
Yes, Your Honor.
Okay. All right. Time is flying here, so I do want to address briefly the constitutional protection claim for a moment. Again, Ramos, it's a vacated decision, not binding, but it can be looked to at least for some guidance, though it's not binding. Did find that there can be judicial review of constitutional claims asserting racial animus or ethnic animus, and that Trump versus Hawaii deference doesn't preclude factual examination for discrimination, and that the Arlington Heights test does supply the general framework for discerning whether or not there is an improper racial motive. Has anything, in your view, changed? Now, of course, the decision also said that there was insufficient evidence to show that the statements made by then President Trump actually were a motivating factor and had substantial influence over the decision makers, which was the secretary in that case. And therefore, that's why the plaintiffs had not proven a equal protection claim. But in terms of the overall question about whether there's judicial review, whether the court can consider the question, whether or not the Arlington Heights mode of analysis is still relevant, has anything changed in your view from the Ramos now vacated decision?
I'd first note that plaintiffs brought this under the APA, and this is a separate claim. So under the 705 stay, 705 postponement, this constitutional claim is not part of their APA claim, so I don't see how it can be part of their motion to postpone.
Part of their motion?
Motion to postpone under the APA.
Since it's not an APA claim.
Since it's not an APA claim. However, if you disagree getting into the claim itself, the argument now is that no, Trump v. Hawaii is the correct standard, even looking at the vacated Ramos decision. You, Your Honor, in your original motion to dismiss determination in Ramos and applying the Trump v. Hawaii standard, noted that it didn't apply in the Ramos case because the decisions there did not involve national security as a basis for terminating, and they did not involve foreign policy reasons for the basis of termination, as well as looking at you broke them out, but the third and fourth piece being the constitutional rights of the individuals. Whereas here, we're dealing with, at least in the termination sphere, we're dealing with a termination that is explicitly based off of national interest. And the secretary lays out what she views as the national interest. And that's a standard that is not discernible for the court to
So
analyze.
let me ask, maybe I should clarify that the equal protection claim challenges both the vacatur as well as the termination decision? Let me
Yes.
just look. All right. So the vacatur decision, to the extent that's being challenged under the equal protection clause, was not based on national interest. That was just based on the prior secretary acting outside the bounds or creating a problem, doing something novel. It's in the decision to terminate that invokes national security, right?
Correct.
So you could have a differential. Trump versus Hawaii, there could be a differential analysis between those two decisions.
It could, I think the vacatur, because it does reference looking at the statute, looking at and the interpretation of the statute and the executive order of the president, that it's all kind of brought together as a package for foreign policy reasons and the national security of the United States.
And
Sorry, the national interest of the United States.
national interest.
Yes.
And I understand what the national interests are. That is in part based on alleged gang activity by TDA, correct? That was cited, I believe.
Yes.
We've talked about that and whether there's evidence to support that. But what is the foreign policy implication then of the vacatur and the earlier termination of the designation?
If you look at the language of the FRN on page 9043, Secretary Noem notes that U.S. foreign policy interests, particularly in the Western Hemisphere, are best served and protected by curtailing policies that facilitate or encourage illegal and destabilizing migration. And so that determination of national interest, which takes into account, it's an expansive standard. It takes into account foreign policy, public safety, national security, migration factors, immigration policy, and economic considerations. So these are all pieces that are going into the national interest determination. And that would
And the argument is that allowing TPS status attracts illegal entry? Or what's the connection between continuing or not continuing TPS status for those who are already here and the national interest in not facilitating illegal entry?
Sure. I mean, Secretary Noem also notes other programs that were undertaken under the prior administration. And the CNHV program is one of them, in which individuals were able to come, and then with the redesignation of Venezuela, were then moved into the TPS status, temporary protected status.
But how, I'm trying to figure out the interest is perspective. That is safeguarding the national interest, national security, wherever we want to put it. And we don't want to encourage illegal entry into the United States. I understand that interest that's being asserted. What I'm having a hard time seeing is how is discontinuing the status of present folks or extending their status or not extending their status, how does that affect illegal entry?
I think this is one of the issues that goes to the Secretary's determination and shouldn't be looked at by the court.
Well, I'm just trying to understand the logic of it.
But and Secretary Noem states that I understand the perspective argument, but that it's been used in the past to promote illegal immigration because of the redesignations that then recapture, or I guess capture individuals who had come unlawfully and trying to get back, I believe she says, to like the core meaning of TPS status.
So it is your position that the court should not test or inquire into whether in fact there's any logic or factual basis for either assertion of national interests based on, for instance, TDA gang or foreign policy assertions that for which there's hard to see a connection, that the court can't consider that?
Yes, I think that's straightforward analysis under the 1254A, B5A jurisdictional stripping provision. That goes to the termination grounds that the secretary relied upon. That fits in, I think, everybody's definition of determination. In addition to that, a national interest is such a broad standard that it's most.
Well, but even the Ramos, now vacated Ramos decision said that 1254 does not preclude a constitutional based challenge. Notwithstanding the jurisdictional stripping, it did allow that, and the court made an inquiry, just found as a factual matter there was no racial motivation.
Well, I think if you're looking at Trump, if you're looking at the constitutional grounds, then you look under the rubric of Trump v. Hawaii, which looks for a rational basis, and it must be plausibly related to the government's stated objective. And here, the stated objective is to protect the national interest. So we have instruction from the Supreme Court that any rule of constitutional law that would inhibit the flexibility of the political branches of government to respond to changing world conditions should be adopted only with the greatest caution. So yes, my argument is that in the context of national interest, that is such a broad standard that is firmly committed to the executive branch that it would be inappropriate for the court to go in and weigh the evidence that the secretary weighed.
All right, let me pause right there and get the response that Trump versus Hawaii has greater application here because unlike Ramos, there is at least an asserted national interest in foreign policy component, at least as it affects termination, not vacatur.
Right. And I should say the APA makes reviewable claims that agency action is contrary to constitutional right. That's in the scope of review provision of the APA. So we are raising this claim in support of the postponement motion as well. But to answer your question, Your Honor, you alluded to this earlier, national interest, that's the word the statute uses. It's not obvious that that means the same thing as national security. And in the Ty v. Ashcroft case, which we cite from the Ninth Circuit, the government had tried to claim that a non-citizen who was committing crimes presented a national security concern. And that was in an immigration detention context. And the court said, look, just the fact that it's a non-citizen committing a crime doesn't somehow transform this into a national security issue. I think Your Honor certainly can look underneath the reasons that are given and see, are the reasons given actually national security concerns, or are they just waving the term around when what they're actually talking about is just crime? And that's certainly relevant here because the record evidence shows that, there's not a shred of evidence that a TPS holder is even a member of this gang that they're talking about. And as Your Honor alluded to at the outset, under the Dudley Declaration, there's no evidence in this record or anywhere else that I can find that this gang is engaged in anything other than, it's not even the gang, individual members of it. There are some people here in this country who are committing some crimes, and that's it. And everything else that they've said about this is just a pack of lies. I mean, the Colorado apartment complex, that's been debunked. It's Exhibit 29 of the McLean Declaration. There's no substantial organizational presence. So they can't just make pretend that it's national security and then displace all of the court's review authority. For the constitutional claim, the Fifth Amendment constraint to have any force, at some standard of review, the court gets to look and see whether there's actually any there.
So your view is that in order to try to invoke the deference under Trump versus Hawaii and the invocation of the claim of national security or national interest, that the court should first understand there's a distinction between the two. National security has certain implications that are different from just national interest generally, and that the court should examine whether there is in fact a national security claim here that truly involves national security. So you almost have to like look at the facts in order to determine what review of the facts, what the standard of review of the facts are. You have to look at some predicate questions.
Yes, Your Honor, in much in the way that would be true of a jurisdictional question or other questions. That being said, Trump v. Hawaii is very clear that the deferential standard of review there is a product of several different things. One of them undoubtedly is the invocation of national security, but also it's that the claims involve the entry of foreign nationals. And they say that a few times in the opinion. And then if you look at footnote 5, where they're specifically refuting the dissent's claim that Arlington Heights governs, and they say what makes this a case triggering facially legitimate and bona fide review, which they construe as rational basis review, is the fact that it's about the entry of foreign nationals.
Yeah, no, I'm aware of that. That you would argue that's the primary point, and the fact of national security or not, or foreign policy are additional factors, but just, and they would argue, well, that's just one or three or four factors, and therefore I understand that.
And the other one, Your Honor, is they say it's a statute giving authority to the president that exudes discretion or in every clause to the president. This is a statute giving authority to the Secretary of Homeland Security, not the president. And I think that also matters because it's not a separation of powers issue in the same kind of way. Here, Congress set a set of criteria, statutory criteria, and gave the secretary authority to effectuate what the statute is authorizing. So there's no Article 2 overlay, nothing about presidential power operating here. Those are two reasons why, apart from this national interest, national security issue, why Trump v. Hawaii doesn't govern. That being said, I think we would request that the court, as you did in Ramos, look at whether or not we can make our discrimination claim under Trump v. Hawaii, because this case is much stronger than Ramos, even though I thought we had a good claim in Ramos. And this claim is much, much stronger on the anti-discrimination claim than Ramos. If Your Honor, if you look at, we filed it as an appendix, it's like Appendix A to the reply brief. We showed the timeline of the decision-making here. And what's happening here is the secretary is sworn in on January 25th. She makes the vacatur 3 days later. So whether it's under Arlington Heights or Trump v. Hawaii, that kind of compressed time for decision-making is truly extraordinary. Then the next day, she goes on national television on Fox News to announce the decision. And she, makes this slur that says, the people of this country want these dirtbags out. That is not just campaign trail statements or even just separate statements about Venezuela or Venezuelans. It's explaining the decision to the public. It's the reason she gives for why we have done this to the public. It includes this racial slur. Then 3 days later, they make the termination decision. And again, the next day, she goes on TV. Now it's Meet the Press. And she says, the TPP program has been abused. Like, again, she's explaining the decision. And she repeats these lies about them emptying the prisons and mental health institutions. And she says at the end of that, so we are ending that extension of that program. Again, it's the reason she is giving to the public for why she is doing this has this lie in it. And they say, oh, we're pointing to early statements. But the reason we pointed out in our briefing that she has been making this statement for over a year, Your Honor, is to make the point that she's been lying about it for so long, she has to know it's a lie because it's been debunked again and again. We cite, I think it's Exhibit 29 to the McLean, I can't remember which one it is. There's an exhibit 26 to the McLean Declaration. We show that this lie about emptying the prisons was debunked long ago, and they keep saying it anyway. And that's a racist trope. The Young Declaration shows Elliot Young, who's a historian of immigration. He talks about how this lie about they're poisoning the blood by sending bad people, that goes back 150 years. Same racist justifications used again and again. And here it's in the decision by the decision maker. We didn't have a statement like that in Ramos. We had one reference to America First in notes explaining a decision, by the secretary. That's it. That's all we had. And our argument was primarily based on cat's paw, as you may recall. And here, we don't even need to use the statements of President Trump we don't need to use any extraneous statements either. We're just talking about why she says she has done this. So I think it's quite a strong case under Trump v. Hawaii itself, because Trump v. Hawaii, does allow for the consideration of extrinsic evidence. It cited the president's statements, but ultimately, the court there found, whatever you think, the court found that there was persuasive evidence of legitimate ground in national security concerns for the decision there. And that's what they said. There was persuasive evidence before that. So they found the decision could be explained by those persuasive grounds. And here, where is the evidence that they considered something other than what she said on TV? What did she say on TV about why they're doing this? And there's nothing comparable to that in Trump v. Hawaii.
All right, let me turn to the government and ask, why shouldn't statements which seem to attribute group characteristics and based on generalizations and very negative generalizations about prisons, emptying the prisons, emptying mental health facilities, membership in the Trans de Aragua, it seems to defame an entire group of over 600,000 Venezuelans who are here with this image. Isn't that almost the definition of racism, when you make a generalized stereotype about an entire group and then take action on that, when there's really appears to be no basis for that generalization?
I don't think that that's what the action was taken on. I think we have to look at the text of the FRN to see all of the reasons that were taken into account for the termination.
Okay, before we get to that question, wouldn't these statements, whether or not they motivated, that's what you're arguing, the actual action, aren't they problematic aren't they indicia of a view that really engages in racial stereotyping?
I think that the plaintiffs are taking them out of context. I think when she's talking about dirtbags, she's talking about individuals who are Tren de Aragua members. And so you have to look at the statements themselves. But regardless of that, the proper standard is to go back under, as plaintiffs are also agreeing, to look at Trump v. Hawaii and see, is there a reasonable justification for this determination?
Well, and when you do that, you do have to take into account, as I think even the Ramos decision here looked at, whether there are statements that were made that might inform what the reason was. It's true, if you apply the Trump versus Hawaii standard, it is more deferential, it is more akin to rational basis, and whether or not you can discern a legitimate basis. But I don't think that means you totally ignore, the context. And here, if you look at least the factors that seem relevant under Arlington Heights, the compressed time frame, and I guess we'll see later on, what was exactly before the secretary and what was it based on. I would have to assume at this point that none of the usual documentation that you see in termination, extension, designation processes under the TPS were followed here. That is a country report, a country conditions report, the input from the State Department, et cetera, that whole process, which usually takes months. I would assume within this compressed time frame that didn't happen here. I don't know if you know the answer to that or not.
I don't know the answer to that. I have the language from the FRN that says that Secretary Noem did consult with the State Department and did look at the conditions. So I think making a fast decision is not on its own a reason to overcome the secretary's determination.
Well, but it may inform whether or not one can, even under the Trump test, Trump versus Hawaii test, whether one can reasonably discern, or whatever that language is, attribute a justifiable explanation. And I would think circumstances might inform that question. Maybe it's like Arlington Heights with a high degree of deference, but there's still some logic to looking at all the factors, it seems to me.
You can look at, yes, the standard allows extrinsic evidence, but again, the ultimate determination is whether or not the decision was plausibly related to the government's stated objective.
Well, all right. So the question that I'm confronted with is under the postponement statute under 705, which essentially embraces and adopts the traditional standards for interim relief under Rule 65, right? The balance of hardships, irreparable harm, public interest that I have to consider, which way does that go, and the degree of strength on the merits. And I believe that the sliding scale test applies under 705 as it does under Rule 65.
My understanding is that the equitable analysis is the same. I don't recall if there's a case that specifically draws that distinction, but it's the same.
All right. Well, I will take the matter under submission, at least this motion. The argument has been helpful. I appreciate council's input. But that is the framework, and obviously there are some threshold jurisdictional questions that I have to address before we go anywhere and or go any further, that I've got to address that. So I will do so. Let me ask, I know that action is going to be taken, the first consequential action occurs on April 4th, is it?
April 3rd is when the employment authorizations expire, and I would just point, Your Honor, there's evidence in the record, the Faro Declaration, also from Poste Palma, which show TPS holders are selling businesses, lawyers are trying to figure out, what to do. People are postponing school, all kinds of things. I know it's a lot. It's kind of important. Those are short time frames because of the nature of what's happened. We would just respectfully request a ruling as soon as possible.
Okay. And in terms of the motion for discovery, I think I've already indicated my view is that what the parties should do first and foremost is to try to agree on what the administrative record is in this case. And then I think then I can approach, if there's additional records that are then sought, then I can see in that context. But I think I need to see what the administrative record is first. So the quicker you can put that together, the quicker we can tee up any motion for discovery if there is one. So I'm going to direct the parties to meet and confer immediately about that.
Your Honor, we appreciate that and certainly would seek to meet and confer with defendants about the administrative record. We would ask for an expedited production timeline for the administrative record. As a point of reference, in Ramos, Your Honor required the production of the administrative record for 2 countries 10 days after the jurisdictional finding, and the other 2 countries 7 days after that. And we would request in these circumstances, given that we're talking about 1 country and 2 hastily made decisions that went into effect very quickly, that nothing greater than that timeline be allowed under these circumstances. Also, Your Honor, in the Ramos context, the guidance that Your Honor provided about what was part of the administrative record at the end of Your Honor's order on the motion to dismiss was extraordinarily helpful in providing some guidance about what should be part of the administrative record. And we request that guidance again be provided here, perhaps with even greater specificity in light of the fact that we have learned much more from the Ramos experience about some of the limitations and the limitations and the extensive motion practice that was required to try to get a more complete record. The guidance that Your Honor provided in the motion to dismiss order recognized binding precedent that all documents and materials that were directly or indirectly considered by decision makers and relied on by subordinates should be part of the administrative record. We've also learned in the context of the Ramos litigation about what should be part of the whole administrative record, and we would respectfully request as much guidance as possible from the court, both about the timeline and about the scope of the administrative record.
Right. Well, first of all, with respect to scope, I see nothing that would cause me to deviate from my view of what is properly within the administrative record. Last time, I've not seen any change in law, and there may be some law with respect to extra record stuff and when the appropriate timing of that may be. But I don't see any reason to deviate from my view of what should be in the administrative record. I think that was based on clear case law. Now, if you start to get into dispute and you have more specific questions, I can address those through my normal process of a joint letter addressed to me for an expedited consideration. And I agree that, I have to decide the jurisdictional question first, because if I find that there's no jurisdiction, there's nothing for me to do. But once I do decide the jurisdiction, I do expect the parties to produce a record within 7 days. So that doesn't preclude you from meeting and conferring now and saying, well, here's what it might look like. There's no reason to start talking now and trying to see, even if it becomes obviated. If I find, for instance, no jurisdiction, it's worth the exercise. So I would urge the parties to get together immediately, start talking about that, so that if I do find jurisdiction, that administrative record can be filed shortly thereafter. And if you have a dispute about what goes into the administrative record, based on my criteria, send me a joint letter and I will resolve that. So that is my hint in terms of timeline and scope.
We appreciate that, Your Honor. I'd also like to make one additional point, which is that our motion to shorten time was merely a request that this court permit us to propound discovery, not a request that this court make any determination about whether the discovery that we're seeking is proper. That has been prevented because of what is effectively a unilaterally imposed stay on discovery by the refusal to allow a conference that would have opened up the discovery process. We're not seeking expedited discovery or a determination about the propriety of any discovery requests, but we do note that in addition to the administrative record that is the basis for any judicial review of an APA claim, there's two parts of our case that require, in fact, some extra record discovery. One is the constitutional claim, which requires a consideration of the motivation of the decision maker. My colleague spoke about the statements that were made, for instance, after the decisions, the vacatur decisions and the termination decisions on the media. We would like to know and have a right to know, to be able to develop our equal protection claim, what the secretary relied on, what documents she considered to prepare for those media interviews in which she described TPS holders and Venezuelans more broadly as dirtbags. That would not be part of the administrative record. It is a post hoc rationalization, but it is essential.
Well, we don't know. I'm sure there may be something in the administrative record because there's only days before that might be relevant. That's why we need to see what the administrative record is first. But to the extent you are asking in advance for permission to seek extra record evidence, I think the record is evident that depending on what survives here, or what if there is jurisdiction, including jurisdiction over constitutional based claims, I think the Ramos decision and what I've held in the past, and in Trump versus Hawaii, I think leaves the door open for extra record evidence. But it's part of what I'd like you to meet and confer in advance on. Now, whether you can propound discovery, let me ask. With respect to obviously you don't need to have a case management conference it's hard to schedule one until you know what I'm doing here, but I will probably set a case management conference either way, whatever I do. Well, if I find there's no jurisdiction, we still need a case management conference, because then that's going to invite a motion to dismiss, I assume, a formal motion to dismiss. But, or if I don't, and we need a case management conference, figure out where do we go from here, what's the next motion, et cetera, et cetera. So I will set a case management conference in short order. Whether you want to propound something in advance of that, I mean, you can, and I can grant that for good cause, in advance of the normal process of waiting for the case management conference to propound discovery. However, I would not require the defendants to respond to that until the jurisdictional issue is decided. But if you want to propound that as a cautionary measure just to get things rolling, I will permit that, with the understanding that no response is expected yet until I rule. And then, you know, once I rule, maybe you can stipulate to a response time if that's appropriate. So
may the government have a chance to respond?
Yep.
Just I'll do my part to keep it brief. The government's position is that there should not be any administrative record production prior to this court's adjudication of the motion to dismiss. And here, plaintiffs just filed their first amended complaint a few days ago. So there's now an additional country added. That's going to be considered in the government's anticipated motion to dismiss. There should be adjudication of that first. I believe that's the whole reasoning in the In re United States Supreme Court case, that threshold jurisdictional arguments need to be resolved prior to any administrative record order. And I'm not clear.
Well, that's why I said I'm not going to require a record be filed until I resolve the jurisdictional question. But once I do, even if there's a motion to dismiss, because I'm going to look at the jurisdictional question pretty much on the merits, it may not be the ultimate decision, but it's enough to get the process going. I don't agree that I have to defer any kind of action in this case until a motion to dismiss has been brought and adjudicated. It is not uncommon to have a case management conference, to have discovery ongoing. It's up to the court whether it should stay discovery pending a motion to dismiss. And sometimes I do, sometimes I don't. If you want to make that motion, you can make that motion. But my intent at this point is that since I will have looked at this question quite closely, perhaps not in the context of a 12B1 or 12B6 motion, but this is not like just out of the box. You'll see what my ruling is. And if I find that there's no jurisdiction, you don't have to worry about it. But if I find that after looking at everything that there is, there's enough there to start the process of putting together there will be a process of putting together an administrative record. And I would not, highly unlikely, I would await a full motion to dismiss to begin that process. You can still move and convince me, but I'm just giving you a preview. Since this is unusual, since this is a very robust, among other things, merits-based preliminary injunction, I have to now look at some of these threshold issues very closely. So that's what we're going to do. So what I will schedule a case management conference either way once I get this ruling out. But I would like you to meet and confer to start thinking about both discovery, what that is going to look like, what the record's going to look like, the administrative record, and how we might proceed. Is this something that, motion to dismiss, then followed by motions for summary judgment, or do you skip motion to dismiss and just do it all in summary judgment? You move for summary judgment on some claims, not others. We set up a bench trial on issues where there may be some factual questions. I don't know, but I'd like you to think about that.
Your
Okay.
Honor, may I raise two additional points? Just,
Yeah.
As far as if the court determines that it should postpone the vacatur and the termination, I would note that there are 3 other cases that are looking at this exact issue. And so for you to take that into context in the scope of any decision. And then also if there is to be a stay or a postponement, we would request a couple days for the government to determine whether or not an appeal should be sought.
Sure. All right. Anything further?
And if you want to be heard on the question of whether the relief should run, at the rule or
The question
with
of,
respect to the other cases or not, I'm welcome to address it if your honors.
well, if you have anything to add, I've read the papers and I understand, we're all dealing partly in a bit of a state of flux here. Things are moving as we speak, probably, on this question about scope of any stay, et cetera, et cetera. I understand the arguments pro and con. I understand, and I've read the concurrence in the Ramos case, so I'm aware of the issues. I am aware of at least 2 other cases that are pending. Is it 3 or 2 other?
3 now. There's some overlap. So this one is, there's one in Eastern District of New York that's solely on Haiti. There's one in Massachusetts. Yes,
and then there's one in Maryland.
Yes.
Yeah, Maryland's only about Venezuela. Massachusetts is about both, and New York is about Haiti. The other thing I would just say, there's a footnote in the reply brief where we collect the cases as well since Ramos. It was just since, I can't remember, 2021 or something like that, where the courts have issued universal, whether it's vacatures or in some cases injunctions, and those have been upheld, including recently in the Ninth Circuit is an injunction on the birthright citizenship order. And then, it's in the papers, but at this point it's well over 84,000 members. They're in every state. You cannot limit to the Ninth Circuit and give relief to the party. So already you can't do that. And so, how exactly you would enforce a postponement limited to NTPSA members, and the government doesn't even try to explain how that would be possible.
No, I understand the arguments, and you have an organization here as represented, and it's provided by declaration or substantiated by declaration that this is a membership organization that is nationwide with members in all states. Whether that's relevant or not, I don't know. We'll figure that out. All right. All right. Thank you, everyone.
Hearing is concluded.
Señores, buenas tardes. Gracias a todos los que sintonizaron. No olvides compartir, comentar y darle like a la transmisión. No suscribirse al canal. Señores, todo ha terminado en el 4 de abril. En 7 días dijo el juez que iba a tomar una decisión. Nos vemos en una próxima. Bye, bye.